Mr. Alcorn, in your written testimony, you expressed support for a bill I introduced, H.R. 6141, the Fair Access to Justice for Union Members Act. This bill allows union members to hold their unions accountable in court without the delay of exhausting internal union processes when their rights have been violated. I wonder if you could speak from your experience with the Trader Joe's union, how you think this bill would help workers to protect their rights under the Labor Management Reporting and Disclosure Act.
Thank you. I think this would be really helpful to workers because what I experienced with the Trader Joe's United was people trying to be union bosses and using whatever they could to do that when they organized, and then they wanted to have unfair election of officers that were not democratic, and they claimed that they could do this because they were a new union, and that is not protected under the LMRDA, and it should be. Whether it's a new union or not, we should all be given a fair election of our officers, because essentially then they can do, if it's not a fair election, they can go and do whatever they want, and then they'll create the grievance procedures. We didn't have a constitution at the time, so they were going to create all this. So rather than me have to go through that, I think it'd be best for workers to be able to have another way of getting justice.
Thank you, Mr. Alcorn. Mr. McGrath, turning to you, my legislation was actually inspired by Jewish members of the Association of Legal Aid Attorneys, and these union members thought their rights were violated by the union's proposal of an anti-Semitic and anti-Israel resolution. Unfortunately, when the union members sued to stop the vote, they were instead sued because they had not exhausted the union's internal appeals for 4 months before going to court. And Mr. McGrath, current law set that 4-month time limit for exhausting appeals, but my bill eliminates that time period. Can you describe what problems tend to arise for union members if they have to go through the union's internal procedures for 4 months before they're able to go to court?
Yeah, I think that in our clients' experience, so they're entering a 4-month process that is run by the very people who they're trying to seek relief from. And so it's really not a fair fight, or it's a very slanted field that they start from. And so as they go through this process, they could have statements taken, they could have hearings conducted, and there could be decisions that come out of it at the end of the day. And typically, at least our clients have always had it go against them because the very people who control this, either they or their friends, control the process. And then we actually had clients who went through this exhaustion process in their matter, and then when they came to us, we were able to bring their matter to court, and the other side, the union officials said, oh, look, there's all this sworn testimony, there's this decision that's already been had, we win. And so not only did we have to deal with the typical contentions of court, but we had all this baggage that got brought in from the exhaustion period that our clients had to go through.
Well, thank you, sir. My legislation supports the workers' rights by ensuring they can go directly to court, as you point out, to protect their rights under federal law without waiting for the very union violating those rights to decide their fate. Mr. McGrath, in your written testimony, you recount a story about a client whose union violated its own Bill of Rights for union members and deliberately misled its members about terms the employer was offering during negotiations of a collective bargaining agreement. In your experience, how common is it for union members to have little or no say in negotiations over the terms and conditions of their employment?
I think this is something that varies nationwide and union to union. We have seen unions that are very transparent and ask for input, and they ask for, they keep members updated. But obviously we've seen the other side of the pendulum where, like, as in this case, the union's members, our clients' opinions weren't taken into consideration, and then they were actually lied to about a proposed collective bargaining agreement that was worse off than what the employer actually was offering. And so when they had found, they were basically harassed into signing this deal, and then they found out days later from the employer, like, hey, we actually gave you everything that you had said you wanted and better raises, we don't understand. And for its efforts, the employer was sued for that too. But
do you think union members should have the right to vote to ratify their contract?
I think from every client I've ever heard from, they absolutely would want that right to do it because to them, they're voting on something that controls their livelihoods.
Thank you, sir. Mr. Chairman, I yield back.